recently seen an upward curve in the number of COVID cases in the UAE. And therefore, I request everyone to be cautious and strictly follow all the guidelines by the authorities. Remain healthy. Now I hand over to Paddy for his address to the members.
Thank you, Neeraj, and really very happy to be back amongst the CA fraternity once again. I'm double hatting here as a past chairman of ICA Abu Dhabi chapter, as well as the president of IPBG, and always a pleasure interacting with the CA chapter members and IPBG members as well, albeit this time virtually. And again, welcome once again to this very interesting session on litigation funding and FDI. I mean, it's quite pertinent, the timing of this particular session. And as Neeraj mentioned earlier, COVID-19 has meant that, we're seeing a lot of difficulty in terms of the economic environment. We're also seeing, receivables being pushed, companies finding it difficult in terms of collecting. I am aware that several entities in the UAE, they have changed their credit period from, 30 days to 60, some to 90, and some to even 120. And under these circumstances, companies are very watchful when it comes to money. Cash is king today. And under this context, if you're not on top of your receivables, then it becomes extremely challenging. And there are situations wherein some things can go into litigation. And many of us, they don't want to get into this route because of the costs which are associated with it and the complexities, the legal structure, etc. We're not very familiar. That's where the role of experts come in. And we would like to hear them today. And they would be speaking on this very, very interesting topic for all of us. Similarly, if you look at UAE, it has been a pillar when it comes to an investment destination for FDI. We always had this 51-49% rule when it comes to LLCs. When it comes to expatriates owning 100%, it has always been a challenge. Many entities were looking at sponsorship system, which is not ideal. You had the new commercial companies law, which had a different profit distribution when it came to ownership and profit distribution. But really, the solution to most of the problems was the foreign direct investment law, wherein you're looking at certain sectors where 100% ownership is looked at by foreigners. And to hear more about it, we have our experts today. Speaking about IPBG and its activities, similar to ICI, we have been also been involved with the various communities in terms of relief efforts, particularly in terms of repatriating many people from UAE to India. I spoke to the embassy very recently, and I understood that around 600,000 people were registered with the embassy, and about half of them have gone back to India, not permanently, but many of them for specific needs. And we are expecting some of them to come back to the UAE. And we will continue to provide the support to anyone who wants to go back to India. And we have other ways in which we are supporting the community. Speaking about IPBG's activities, we have a networking event planned for next month. We have a discussion on ICV3, which is a very interesting topic, given that we have multiple players, including Aldar, Department of Economic Development, and ADNOC, who are joined up in terms of ICV. We have a networking event planned for our members, wherein we want to provide them a platform to speak to each other about their business so we can know each of you better. And last but not the least, as a social event, we have a session on numerology. So without taking much further time, I hand over the floor to Shafiq. Thank you very much.
Thank you, Paddy. Good evening to all. I'm CA Shafiq Nilail, committee member of the ICA Abu Dhabi chapter and team media and student affairs. It's my pleasure to introduce the speakers of today. I have a big task. In fact, we have 4 speakers covering 2 sessions. So the first speaker is Dilip Masant, the Chief Executive Officer of Phoenix Advisors. Mr. Masant is the co-founder and CEO of Phoenix Advisors Limited, an Abu Dhabi-based firm focused on co-funding of litigation in mature and emerging market, as well as credit opportunities in the GCC and surrounding regions. Mr. Masant has over 20 years of international experience working with institutional investors, MNCs, banks, ultra-high net worth individuals in the US, Middle East, and India. Mr. Masant previously served as the managing director of SAS Asset Recovery, a Cayman Island firm specialized in complex cross-border litigation, asset recovery, and dispute resolution. Prior to this, Mr. Masand also served as the co-chair of emerging market practice for McLagan Stern LLP, a New York-based firm. He holds a Juris Doctor from New York Law School and Bachelor's of Science from Boston University, and is a member of the New York State Bar Association and a qualified legal consultant in the UAE. He also serves as an advisory board member of New York Law School's Alternative Dispute Resolution Committee. So the next two speakers are from among us. They don't need any introduction, and especially to me personally, they are very close as a friend, maybe as a mentor, as a guide. So the first one I'm going to introduce is our own Advocate P.V. Shaheen. Advocate P.V. Shaheen is an advocate and legal consultant with almost 3 decades of experience in UAE and India, with full rights of advocacy in all courts of India, including the Supreme Court, and also DIFC courts in UAE. He is the managing partner of Goodwin Law Corporation and has extensive knowledge and experience in all fields of UAE laws. Shaheen is a director on the advisory board of the First Law International, which comprises of 85 law firms from 81 countries and 17,000 lawyers. Shaheen is also the vice president of IBPG Abu Dhabi. Shaheen is a philanthropist, an avid reader on philosophy and spirituality, and an active critic of political social issues. So the third one is our own Rajiv Shah. Where is he? Yeah. So Rajiv Shah is an Indian chartered accountant. He has over 24 years of professional experience. He headed the Middle East practice of A.F. Ferguson and Company Management Consultancy, now Deloitte, and then served as the Group CEO and Group CFO with Emirates National Holding LLC Abu Dhabi. He started his own venture, GIC Consultants, in 2013. He is the founder and CEO of Capita World Middle East Limited, a fintech startup. Rajiv is the past chairman of Abu Dhabi chapter of ICAI and current general secretary of the Indian Business and Professional Group Abu Dhabi. By hobby, Rajiv is an author, a best-selling fiction novel, and an avid squash player. And above all, he is my partner in badminton doubles. And the last but not the least, the speaker is Shayan Dasgupta, legal consultant, Goodwin Law Corporation. He is heading the AI, blockchain, and fintech. Shayan also practices in corporate and commercial laws, including but not limited to cross-border mergers and acquisition, corporate restructuring and asset management, joint ventures, PPP projects, commercial agencies, real estate financing, and the list goes on. Before his stint at Goodwin's, Shayan was an in-house counsel at Vedanta Limited India, a subsidiary of Vedanta Resources Limited UK, where he gained diverse and valuable experience in corporate and commercial matters, including maritime disputes, PPP projects, and civil litigation. Shayan holds BBA and LLB from Symbiosis, Pune, India, and pursuing MSc in AI and blockchain from the University of Law, London. So with this, may I request Dilip ji to take over the proceedings from here. Over to you.
Thank you, Shafiq, for that introduction, and it's an honor to be amongst you, such an illustrious panel and such an accomplished group of professionals. And I will say, when I came from the United States to the UAE about 8 years ago, it was this Indian community in Abu Dhabi that really opened my eyes to hard work, achievement, and how you've helped the country grow. So again, thank you for having me amongst you. I thought what I would do tonight is give you a bit of a history of litigation funding, third-party funding, a global view, and then distill it down to hand it over to Shaheen and Rajiv to tell you about the very creative application that they've developed for the UAE market and for some of the debt issues and collection issues. So if you bear with me, I will just share my screen. And I think you should all be able to see this. I'll try to go to slideshow mode. There we go. So litigation funding, as I said, it's synonymous with something called third-party funding. They're the same thing. I usually like to start with this quote, as people who know me have heard me say. Third-party funding, litigation funding has been around for hundreds of years, but it has been controversial, I would say, until the modern era. Lord Jeremy Bentham in the early 19th century, when describing it, called it a mischief in those times it seems but too common, was that a man would buy a weak claims in hopes that power might convert it into a strong one, and that the sword of a baron stalking into court with a rabble of retainers at his heels might strike terror into the eyes of a judge upon the bench. What this really refers to is a practice going back to the Roman times and medieval England, where wealthy landowners would fund the disputes of farmers against the landowners that they were farming, and they were essentially trying to take each other's property. So it was outlawed. There was something called the rule against champerty and maintenance. And maintenance is actually the act of a disinterested party to promote, encourage, or maintain a lawsuit. Champerty is a form of maintenance referred to as maintenance for profit. So for many years, litigation funding was not actually allowed and was considered illegal. And then what we saw, the birthplace of modern litigation funding is actually Australia. In 1958, in the county of Victoria, champerty and maintenance was abandoned by statute. It had been considered a crime, and it no longer was considered a crime. In 1993, in New South Wales, it was abolished by act. They did set some guidelines down for the industry, that funders may be liable for costs, that they don't need securities license, it's not a security, etc. What we saw in the 60s is the eradication of the law against champerty and maintenance in England and Wales. So champerty and maintenance were ruled that they are not crimes. Then in 2005, you had a significant ruling by the English Court of Appeal that litigation funding is a legitimate method of finance. In 2010, the Jackson Review of Civil Litigation Costs provided a judicial endorsement to litigation funding. And in 2011, England actually started the first code of conduct for litigation funders. You then come to the United States. And as anybody knows, the United States, we essentially have 50 plus different jurisdictions. So the majority of states allow litigation funding, but you are still seeing that it's coming into various states by court ruling, as opposed to a sweeping permittance at a federal level. But what we have in the US are a lot of entrepreneurial lawyers. You have hedge funds and family offices, and even investment banks that are now active in this sector. How has it evolved globally? It's interesting because from the US, it swung back east to Hong Kong. And in 2017, third-party funding or litigation funding was permitted in Hong Kong in arbitration. Singapore followed suit for international arbitration, not domestic arbitration, but Singapore said that funders must have a presence and $5 million of minimum capital. The UAE, where we've been here for 10 years now, the DIFC has no prohibition. ADGM actually has rules for litigation funders. And you see the emergence of specialized funders like Litwins, who really understand the local market, the need of the local market, and can adapt to the local market. One thing I always found interesting is that, though no one has ever raised this issue, litigation funding is actually Sharia compliant because the funder shares the risk with the party who is seeking recourse. You know, just a few weeks ago, someone contacted me from Jordan. So there's a small funder launching in Jordan, focused on the Middle East. They reached out to us to see if we would co-invest with them. India has had a very active dialogue about litigation funding. The rule against champerty and maintenance didn't exist. Some very interesting rulings on that go back to the 1850s. And lately we're seeing it in Africa. In Kenya, there's small scale. South Africa has funders. And Nigeria is about to have an amendment to its Arbitration Act, which will recognize third-party funding. So where is this industry today? This is some data points, really going back to 2018 and bringing us to today. So you see that there's been an increased acceptance amongst law firms, with 36% of US law firms have actually used litigation funding, which was as of 2017, a 414% rise from 2013. If you look at the size of the global litigation market, in 2018, it was valued at about $11 billion. They are anticipating by 2027, it will go to about $23 billion. And if you look at the concentration of disputes in these markets, you'd have banking disputes, financial service disputes, and a lot of insurance claims, actually. Where it is today, post-corona, is actually that there has been a boom in litigation funding. What we are seeing is that corporates are turning to litigation funding for balance sheet relief. Law firms are partnering with litigation funders because clients just can't afford to pay fees at full. So the law firms have relationships with funders who will come in and pay their fees so they can still pursue recourse on behalf of their client. You see it again, 77% of lawyers consider litigation finance as important to their business models. And it's actually become a very attractive asset class for investors. It's proven to be non-correlated, returns have been significant, and it hasn't wavered with down cycles. As a matter of fact, it increases in down cycles. The other thing that's really driving it is that we've seen a lot of cross-border disputes, and we've seen international commercial courts and tribunals come up in the emerging markets and adapting litigation funding to fund dispute resolution. It has served to help enforce in cross-border issues. So let's say you have a UAE judgment, but your borrower or your debtor is outside, you can bring that judgment into Canada, into the UK, and you can use funding to help fund the enforcement. And I guess as of late, it's being used in asset recovery and fraud and things such as that. So what we have today is quite a significant industry that is global in nature, that is a large asset class. And with that, I will turn it over to Rajiv and Shaheen, and they will tell you, as I said, an entrepreneurial, creative approach that they have put together for this market. So, gentlemen.
Good. Thanks, Dilip. First of all, good evening to everyone. Thanks to IBPG and the ICAI Abu Dhabi chapter, both extremely close to me personally and professionally. And thanks for the opportunity. What we'll do is we'll start with discussing the litigation funding, what it is and how exactly the process works in the UAE. And then we'll move on to the FDI process and what the law talks about. So let me share my screen. Okay, so let's start with litigation funding and management and FDI law. Now, Paddy mentioned and Neeraj mentioned as well, Dilip touched upon it, that nowadays, because of COVID and other issues as well, in UAE especially, a lot of companies are facing high receivables and which have become delinquent, they are not able to recover it, and a lot of companies are facing this problem. Obviously, as accountants and financial experts, as businessmen, we know immediate stress is on the working capital, and obviously then it affects the liquidity, profitability, and growth of the company. And what is happening is, Dilip interestingly mentioned the big numbers that are there for funding. Now, typically, these funders are looking at big cases and they're looking at a large amount of high volume cases to do the litigation funding. What was missing was the litigation funding for the SME category of companies. So we have specifically focused on that, and we will explain how exactly litigation funding works. Because a lot of SMEs feel that it's an expensive route to recover receivables. If I give a simple example, in one of the case studies that we have, a 11 million dirham case in DIFC, which is into DIFC arbitration, just the arbitration fees is 600,000 dirhams. And add to that the expert fees, lawyer fees, translation, court deposits, and so many other costs associated with the litigation. Now, will an SME really be able to bear that cost, where already they are struggling with cash flow and liquidity issues? So there is a need in UAE currently and in other GCC for these litigation funders which exist globally to come to UAE, or some startups in the UAE to come and meet this gap. So one of the initiatives that has been taken now is available in the UAE. What does a litigation funder typically do? A litigation funder arranges litigation funding to absorb all the costs for court proceedings. So as I explained, it could be lawyer fees, court fees, in case of contracting or highly technical subjects, experts would be appointed, arbitrators would be appointed to solve it. Translation costs can run into thousands of dirhams, which are there. So these experts come, these litigation funders come, and they fund the entire cost of the court proceedings and provide effective litigation management to ensure timely and tangible results. So Shine is a lawyer, he may not like me saying this, but what happens at most times is when a lawyer takes up a case, 50% advance is taken and 50% fees is taken when a judgment is derived at. Now, what has been experienced in the past few months is a lot of clients have approached us saying that they have a judgment in hand, but they are not able to execute the judgment. So you all would have felt, whoever has been through this process, that it is extremely difficult to execute the judgment in UAE, because most times you don't know what the assets available in the UAE are. The companies who probably lost the case would strip off their balance sheet of most of the assets, would empty their bank accounts, would sell their assets to a group company. So when it goes to execution, the assets are not available for execution. So you're sitting on a very good judgment in your favor, but there's no money coming out of it. What a litigation funder does is he takes the risk for recovering the money. So he doesn't just stop at the judgment. It is his responsibility then to take the judgment to the logical conclusion of recovering the money from the counterparty. And till that money is not recovered, the litigation funder is not going to get anything out of the deal. So he puts in his money, he puts in his good money after the, say, a bad money of a client. And till that money is recovered after the judgment through a recovery process, the risk remains of the litigation cost with the litigation funder. So this is broadly a role that a litigation funder carries out. I'm going to hand over the presentation to Shaheen from here, who will briefly explain, of course, what Goodwin does, and of course, how the litigation process works in the UAE. Shaheen, over to you. You're on mute, Shaheen.
Thank you very much, Rajiv Saab, and thank you very much, Dilip Saab, for joining us today. We profoundly call you the father of litigation funding in the Middle East, and we are really glad to be with you today. And thanks a lot, IBPG and ICAI, for creating this opportunity, organizing this event, and giving us this platform. So here I am to explain to you the litigation process. It's like asking a surgeon to explain to you the surgery process, how I'm going to cut you, open you, do whatever inside. It's not going to be a pleasant experience, right? If someone tells you, I will take you to court, doesn't sound like I'll take you to a restaurant, okay? So it's a difficult process, which I'll try my best to explain it in the simplest way possible. I would say it's like falling sick, okay? You try a massage, a little paracetamol, some antibiotic. If nothing works, life's contingencies, finally, life is more precious, so you go for surgery, okay? Litigation is exactly like that. It's painful. Sometimes the results are not to be, cannot be precisely predicted also. Even if I tell you 99% you will win, 1% is more than enough for you to lose the case. So are you willing to take the risk? Take a simple case of 500,000 dirhams, okay? You need a UAE national advocate if you have to appear before a mainland court here. And the minimum fees that you're going to pay to a reasonably good lawyer is 50,000 dirhams. Okay, 20,000 will go as court fee. Translation, miscellaneous expenses, expert fee, add everything, it can reach 100,000. This is to do the litmus test, spending your good money after bad money and taking a risk and waiting for 1 to 2 years. And as Rajiv Sab rightly said, sadly, we lawyers are paid for our efforts. We get paid at the judgment. Execution becomes your problem. So this is where a litigation funder, he aligns his interest with the client, and in the client's success lies the litigation funder's success. So that where you can be assured that best efforts on the part of the litigation funder to effectively fund and also manage the litigation process to ensure speedy recovery. Even when you are assured of a speedy recovery, I always preach to my clients, a bad settlement is better than a good case. Whoever is promising you 100%, don't ever believe him. If someone says you 99%, it sounds like 50-50 to me. Okay, so let me take you through this process very quickly. See, when you approach a litigation funder, what is the first process? You have to have an engagement, right? Then the litigation funder, he is putting his good money after your bad money. So he has to do the risk analysis, and then he will ask the law firm to issue a legal notice to start with. So the first process is the letter of engagement. One has to make sure that it's black and white. There are no gray areas. It's very clearly defined what exactly is the scope of work, what is expected from the litigation funder, what is expected from the law firm, and how you're going to get your money and how it is going to be split. Because normally the interest is aligned only when the outcome is split between the litigation funder, the lawyer, and also the litigant. So that is a very important part. Second, once the client submits the documents to the litigation funder or the law firm or the intermediary who is handling the matter on your behalf, you have to ensure that everything is fully disclosed. Anything that comes which is not disclosed and comes from the other side, I mean the opponent side, there is always a lawyer representing the opposite party before the court. So what happens? It comes as a surprise to the lawyer who is pleading on your behalf. So it's always good to the doctor and to the lawyer, be open, be absolutely transparent. Don't mislead, okay? You're misleading yourself when you do that. Then comes, there will be a deposit always, just to ensure your commitment. A small amount, sometimes it's as small as 5,000 dirhams, okay? And then they're ready to go. The litigation funder, the manager, and the lawyer all ready with you. Then comes the preparation of the brief summary. When I say brief summary, always the client is asked to write something like a story about his claim, the relationship, what is the entitlement, how you want to claim, what is the desired result. Okay, this is a summary which comes from the client. What does the lawyer do on that? The brief summary prepared by the lawyers in Goodwins, what we do is first background or understanding. We tell you the client, what did we understand about your case? We do a document analysis, and each document is summarized in 2 lines, document analysis. Third one, we say, these are the strengths of your case, these are the weaknesses of your case. And then the relevant provisions of law and the relevant judicial precedents also. Then we tell you what are the options available. And we tell you what are the strategies and steps that you can deploy before jumping to the court to strengthen your position to cover your weaknesses. Then we tell you what is the suggested course of action and what could be the probable outcome. So you get a 360 degree of the case. And once the client confirms that the understanding is correct, there is nothing more to be stated. Everything what's stated is agreed. You have a 360 degree. I call it the GPS is set now. Now, an average lawyer can run the case because he knows this is a highway, when is the next turn, where is traffic there, at what time you will reach there. There is a proper understanding between the client and the lawyer, which is missing in 90% of the cases, which is being handled in now. Okay, so this is what fills that gap, and there is no surprises after that. So after that, there is any further document information. The client reads it, he finds that the lawyer did not understand something properly, then of course the client has to submit further information and documents. Then the brief summary gets finalized. Then we go to the stage 2. And that is the stage 2 where the risk analysis is being done, as I told you initially. Any law firm which is assisted by a litigation funder, where there is a litigation manager, somebody else's money is also involved. The lawyer is responsible to him as well, just like he's responsible to his client. So he has to ensure that the good money is spent in a good way. So that is why the risk analysis, the result should be 100% the judgment should be possible. And at least 70-75% possibility that should be there for recovery. If the guy is a night flyer and already left the country, the opposite party, I mean, what's the point in suing him, wasting money on that? So litigation funder may give you money only once, next time you will not have a funder after that. The lawyer will be in trouble. He will lose that opportunity forever. So there is a chance of rejection there. Once the rejection happens, from the deposit, a portion, mostly it is 50%, the practice, is returned to the client and 50% is retained. For example, it's 5,000 dirhams. It's a very meager amount of 2,500 dirhams just kept there. But the expenses of the law firm will be much more. I explained to you the way the brief summary is prepared. That itself is an expensive affair. Normally in Goodwins, we charge 2,000 dirhams per hour. So you can imagine how much money we would have spent by then. So this is what happens there. And once it is accepted, that's the green tick you see there, it has to go to the next stage. And the next stage is, once it is returned, I already explained. The other stage is that there is invariably the litigation funder would ask the client for a contract of assignment, and the lawyer requires a power of attorney to represent. The contract of assignment is required for two reasons. One is the funder also has to ensure that whatever is his portion of the recovery, that's coming to him straight, okay? He doesn't have to file another case against the client to recover his portion from him. So this is why the contract of assignment is required. And the dual purpose, as I mentioned, it is sometimes the client also has liabilities. He has other creditors. They may jump on this case and attach the recovered amount, So to avoid that, to protect it, to ring fence it, this contract of assignment becomes very essential and useful. Power of attorney, as you all know, any lawyer would require a power of attorney to represent the client. Then comes the next stage, that is the demand notice. The demand notice and the legal notice, there is a difference between the two. The demand notice is drafted by a lawyer, okay? And it smells the lawyer, but the lawyer is not seen there. The letter goes on the client's letterhead. So once the other party receives it, he may smell the lawyer, but he's not seeing the lawyer. He may attempt to answer it by himself. This could be treated sometimes as an acknowledgement of debt. So you have won 50 or 60% of the case immediately. The moment he writes to you, oh, I owe you money, but I need, okay? This owe you money is an acknowledgement. An admitted fact need not be proved. You will win the case hands down. That is why the demand notice is sent first. Because if you issue a legal notice straight away, he will also, the opposite party will also go to his lawyer and he will start by arguing, who are you? I don't even know you. I have no transaction with you. It was all on cash, never credit. If there was any credit, I have fully paid you. If it is not paid, it is barred by the period of limitation. So inconsistent alternative defense will start there. So that is better to start with the demand notice so that the other party may try to answer something and get caught. So if the demand notice doesn't yield good results, if the legal notice doesn't yield good results after the demand notice, and then you have no alternative, you have to start the legal proceeding. You are taken to the operation theater, the surgery begins. And there, always a good litigation funder, a good law firm should keep in the middle, the center of everything, the possibility for an amicable settlement. That's where you have a happy client, a satisfied client who will give you many more in the future. So this is the good lawyers, the best test that you should apply. Is this lawyer preaching settlement and practicing it, or is he pushing you to the court all the time? The settlement, even a bad settlement, is better than a good case, as I said in the beginning. So first instance court, first time you have to go to the conciliation committee. And once the conciliation committee is over, then you are eligible to go to the first instance court. The first instance court gives you a judgment. In certain cases, the judge may appoint an expert, and the expert, and before the expert, even foreign lawyers can appear. Your other consultants like engineering consultant or financial consultant can appear before the expert. You can put all your papers, you can debate with him. Finally, he submits a report to the court. And when the report is submitted to the court, it's not binding on the court. It is an opinion of an expert. So the judge takes it with that weightage. And both lawyers from both sides are given the opportunity to comment upon the expert report. So if something is seriously going wrong, you have the opportunity to raise your objections, and the judge may return the file to the same expert, sometimes reject your objections, sometimes accept your objections, dismiss that expert and appoint another expert. Everything is possible. So once that expert report is finalized and submitted to the court, invariably the judges are guided by the expert report. It is based on the expert report, then the judgment is issued. So the first instance court, when a good litigation funder with a good law firm, they have analyzed the case, they've done the risk analysis and accepted your case, you can be almost sure that the judgment is in your favor. Okay. So once your judgment is coming in your favor, the other party will go on appeal. You cannot sleep. You have to defend the case effectively before the appeal court also. And from the appeal court also, you will get a favorable judgment. But always, you should keep open the option for an amicable settlement. You should be very clear with your litigation funder, with your lawyer, at what threshold you are ready to settle. 80%, 70%, 90%. You can fix it according to the urgency, how quickly you want the money, and the strength of the case also. A weak case, I would recommend even 60% settle it. Okay. If it's a very strong case, recovery is guaranteed, insist on 100%. You will get it with interest and cost. Only thing you lose is the lawyer fee. Now, appeal court, after that, there is cassation court, which is a Supreme Court, and that's a final court. And only the questions of law or an error apparent on the face of it will be discussed. Nothing else. Simple facts are decided by two courts, they are final. Error apparent on the face of it. Something is black and the judge has written it is white, that kind of a mistake, it can be discussed. Or all the legal issues can be discussed before the Supreme Court. And once the Supreme Court gives a judgment, your fate is decided, and that's it. Nothing more can be done other than a review petition, which hardly brings any different result in experience. Okay. So once that is done, and if a settlement is not reached in any of these stages, all you have to do is put an application before the execution court. So even at the time when you're going for the first instance court, you should try, if there is an acknowledgement of debt, or if there is any document by which your debt can be established in a simple way, the probabilities of the case is in your favor, the balance of convenience is in your favor, you should ask for interim attachment orders on the bank account. If possible, take a travel ban on the opposite party. Even his real estates or vehicles can be attached. So bank account being attached. So he will be, the opposite party will be in a do or die situation. He can't afford to keep everything under attachment and suffer a travel ban for 2 years, the litigation process, So you get a speedy settlement there. If nothing worked and finally you're in execution, you're asking for attachment orders, everything, and you can even ask for a civil arrest to put the person, the manager, in jail if the money is not coming through. So that is how you extract the money. The delay, it doesn't affect you much because courts are allowed to give interest up to 12%. Invariably 9% comes. The court fee is fully recoverable from the opposite party. What you paid for translation is included in the cost. Whatever money you pay to the expert is coming back. Only amount that you're losing is the lawyer's fee. And here, when you have a litigation funder, it is not your problem. The funder has paid it, okay? And he will have a way to recover it, either from the split or however you agree with him on this mechanism here. And then finally, the execution proceeding is done, the money is recovered, that's it, okay? So that litigation process is explained in the previous chart. Now I'm coming to a situation where there was a recent development end of 2019. It was a very interesting development. A lawyer from India, for me, is really, really interesting. Practicing in UAE for the last 25 years, this has been a serious problem. I was acting for many banks in my previous office. We were regularly representing 17 banks. I have represented those 17 banks for 20 years. So I know what exactly the problem we were facing then. You will get a judgment and the company is closed by then. The personal guarantors have gone out of the country. And 35% of the population is Indian here. At least 60-70% of the companies are either owned or managed by Indians. So the personal guarantors has this Indian element in it. And he is sitting comfortably in India. And if you want to sue him there, forget about it, it's for the next generation, okay? I have conducted cases which were older than me when I was in India. So now what happened, the central government has come up with a very interesting ordinance. Any judgment issued by a UAE court, from Ras Al Khaimah to Abu Dhabi, or Fujairah, DIFC court, or Abu Dhabi Global Market Court, it's considered as a judgment issued in India by a competent court in India. Equal, there is no difference at all. There is no discrimination there. You don't have to treat it like a foreign judgment anymore or establish it by filing another case for ratification. Straight away it is accepted. And you don't go to the regular court. You go straight to the execution court and submit an application for executing that judgment, just like how you would have done if you have been issued with a judgment from the Supreme Court of India. It's a very interesting development. So once you start the execution proceedings, in order to go there are Section 13 of the Indian Civil Procedure Code. The conditions are mentioned there. What is required for a judgment to be treated as final? We need to do a review here in UAE itself by lawyers who are qualified in Indian law to ensure that the judgment is properly issued, the notification was properly served, it is final, the certificate that the judgment is final is there, it is issued on merits. The other party was properly summoned, it was not as prayed for because other party did not appear. It is issued on merits. This is what is required. Whether the other party appeared or not, he should have been properly summoned. So once this test is done, ready to take it to India, that is the simple procedural formalities. I don't want to take a lot of time. I would go straight to execution proceedings before India. You have to do the asset tracing of course. You have to search for the domicile of the person, identify with correct address, and then go to the right place. And here, no legal notice, no demand notice, nothing should be done. It should be handled in a very confidential way. You have to jump on it. You have to surprise him by an attachment order, and civil arrest is 3 months. See, here in a foreign country, some people may not bother, going to jail. They'll go inside and for 6 months or 1 year and come back afterwards. I was not able to go on leave to India. That's all they will say. But in his native place, in his backyard, he will really, really be concerned because this is a reputational damage for the entire family. So the moment you show that card, the arrest warrant, go in for 3 months. You don't have to search for his asset. He will search and find it for you. He will bring it and pay you. So that is the coercive methods that you have to use in India in order to extract the money from the judgment debtor. Attach his assets. Suppose he has already transferred his assets to somebody else. In the last 1 year, whatever transfer he has done, if you can identify, search, find out, then there is immense possibility the court may set aside those transfers as transfers done to defraud the creditor. Here again, the funding part is very important here. This is where Litwins or Phoenix come in. Companies like Litwins and Phoenix, they bear all the cost. They have the asset search people. It's not just the lawyer. They have the mechanism, and it requires a district level connection across India. So you need a lawyer who knows UAE law very well, who is thorough with that, and who is thorough with the procedure in India of executing judgments and the connections in both sides. I'm not saying you have to have Shaheen, but this is what you need, okay? So then once the money is recovered, then you may have a problem how to bring the money back to UAE, but it's a good problem. It can always be solved. So I think I'm done. Ajizab, you want me to say something more? Yeah, the most important part is here, how I say the interest of the client and the interest of the litigation funder is always aligned, and the lawyer in the middle has dual responsibility to both. So the client doesn't spend one single penny if there is no recovery, other than the small initial deposit that is done. Is it clear?
So if there are any questions, Ajay, we can take the questions now. I will just stop sharing so we can see the speaker.
Yeah, we have few questions from the members.
Go ahead, Ajay.
So I'll just raise it, and if I request all the speakers or panelists, whoever thinks can answer it. First question from our member is like, they are asking like, what is the Litwin experience and what is the charge mechanism to the client? Like how this experience and charge to the client is happening at Litwin?
Should I answer that? I'll start and I'll pass it on to Rajiv Saab.
Go ahead.
Okay. See, Litwin's experience is actually Goodwin's experience. And Goodwin's experience, you can count on me, is my experience, okay? It's last 3 decades, I would say. Representing 17 banks for 20 years. And you can imagine how many recovery cases I would have handled, both in India and in UAE. This is our experience. We do it on a regular basis. When I was in India, we had on an average 70 cases going to the court every day. And this is what I've been doing. I was not practicing on the original side, the writ jurisdiction in High Court or Supreme Court. I was at the trial court, the hard court, the real place where it was happening. Okay. And coming here, the same number of banks, 17 banks, we were representing in UAE also for 15 years. Then Dilip Saab told me, you should not represent banks now. Don't be conflicted. I need to use you against banks as well. So stay away, When we started with Goodwins, then it was a different story, negotiating with the bank. So we are experienced, and we have UAE national advocates on our panel. They are very well experienced. We have a team of Arabic lawyers in doing this. About the charges part, should I say, or I leave it to the commercial man?
Yeah. So, and then let me speak on the Litvin's experience as well. So, last 3 to 4 months, we've been pretty active in soliciting cases. And now people are understanding that litigation funding as a concept is very new to UAE. And we often get mistaken as a debt recovery company. So the first thing we have to do is debunk that belief that we are not a debt recovery company. We are not going to make 15 calls. We're not going to go and sit in the client's office to recover the money. We don't do that. We enter the scene once the client has tried everything, including debt recovery, and when they want to go for litigation, because that's what a litigation funder does. So now a lot of companies, and surprisingly, we're getting, actually not surprising, we're getting a lot of contracting related cases because those are most complicated. And you'll have a claim, you'll have a counterclaim. So at one point of time, you'll be actually fighting two cases. Trading cases are relatively simpler because there is a purchase order, there's a delivery note, there is a statement of account. So trading cases are relatively simpler. But now people want to go legal, and what we are realizing is because now the cost is not a worry factor for them, they are willing to take the risk on that. As far as the commercials is concerned, slightly difficult question because it depends on the size of the case, the complexity, how much time is going to go. Is it a DIFC arbitration? As I explained to you, DIFC arbitration is almost for a 10 million case, 600,000 dirhams. And if we lose the case, that money is gone. Even if we win the case, it's not certain we'll be awarded the cost by the arbitrator. So there are a lot of factors which go into costing, but typically on an average, we charge around 20 to 30% of the recovery amount. Now, if you're fighting a case for 5 million, for example, maybe the recovery is only 2 million because the guy has only, the counterparty has assets only worth 2 million. So while we can make our business plan as chartered accountants, we love to make business plan and scenario analysis and whatnot, but we can't really expect the entire recovery of 5 million. So in our business plan, for example, we are taking only a 50% recovery scenario. So typically, if you were, I would answer that question. An average range is between 20 to 30%, but it will go case to case. For one client where we're fighting 18 cases right now, every case has a different recovery amount that we have established. So it depends on case to case is what I would say.
Thank you, Rajiv. One of our member is asking about the areas or jurisdiction in which the lit works, and what is the minimum in terms of the recoverable amount which Litwin will take the case. Or in members are asking like, what is the minimum feasible recoverable amount for which Litwin will take the case?
Shine, you go ahead.
Yes. Well, first question is jurisdiction, right? Jurisdiction, actually, we prefer to be in UAE. We have started in UAE and we wanted to continue in UAE. And Dilip Saab is the person who comes from America and he covers the globe, okay? But at the same time, Goodwins is a member of First Law International. And as the person who introduced me, Shafiq Bhai, you told me, you declare I'm the director on board of FLI. So we have 85 law firms from 80 countries. So there is a global reach from Goodwins also. So, but initially, when we are looking at a file, we would prefer to be in UAE for the time being, but we are equipped to handle cases in any part of the world. That possibility is there. And what is the amount that we would normally look for? See, in order for a case to be feasible for a litigation funder and for the lawyer and for the client to be put into a mechanism of litigation funding, litigation management and recovery for that, in UAE alone, ideally the number should not be below 500,000 at least, okay? Then it's really worth putting in all the efforts and trying for it. Little bit here or there, it's fine. Sometimes we may go for a much lower amount for the sake of relationship with a client. Sometimes a client may have a number of cases, but the amounts may be smaller, but still we may take it. So it has to be looked into on a case-to-case basis. And it also depends on the merits and complexities of the case. Too much complication for too little recovery is not a preferred option anyway. Hope that answers the question.
Yeah, I guess, yeah. We have another question from a member is saying that how the repatriation of the funds work? Like, what about the FEMA or RBI rules and others? And how does the ex parte judgment works, as one of the party would have skipped?
Yeah, see, two different questions entirely. I will answer the second question first. How does the ex parte judgments work? Okay. See, invariably, when you have a commercial claim, the claim is against a company, unless it's from a bank where you have personal guarantors also. And as you all know, the limited liability company, the shareholders, directors, manager are not personally responsible unless they have signed a check or guaranteed the debt. Only alternative is at the time of framing the case itself, you have to crack the corporate shell and bring out the persons who is acting on behalf of the company and book them under violation of company law provisions, which make them ineligible for the protection of the corporate philosophy of limited liability. Unless you do it carefully in UAE from the very beginning, you will have a judgment against the company here, and the shareholders, directors, manager may be sitting comfortably in India. You will not be able to recover it against them. No action is possible against them. If you have signed a check, yes, or you should do this by cracking the shell. So this is an exercise which has to be done very carefully in UAE itself if you foresee that there could be an enforcement in India in that case. Otherwise, if the company goes bankrupt or the company doesn't have sufficient assets to pay the debt, you will find the recovery part very difficult. You will get a judgment against the company. And one good part is the courts here, if the manager, general manager named and who's mentioned in the trade license like they do in Dubai, you can get an arrest warrant against the general manager in the execution proceedings. So that is, in a way, a method to force him to come down to the settlement. Now, hope that answers the first question. Ex parte judgments, how it is handled, a little more. See, ex parte means somebody is properly summoned, and despite being given ample opportunity, he did not appear before the court to defend himself. The court cannot wait for him indefinitely, right? One summons notification sent, he has received, did not come, repeat it. Maybe the third time it will go for substituted service, meaning pasting the notice at the last known address or publishing it in the newspaper. Despite that, if he doesn't show, the court doesn't wait. There has to be a finality to litigation also. The court will issue a judgment. At the time of issuing the judgment, your lawyer should be careful not to get the judgment as prayed for, or not to bypass the notification procedure. Do it as many times as possible. And when the judgment is being issued, insist on getting it on merits, not as prayed for. Even if I am claiming 1 million and on merits, the judge is going to issue only 800,000 as the judgment, I rather go for the 800,000 rather than getting 1 million as prayed for. Because that judgment can be destroyed in a foreign jurisdiction if it is as prayed for. It has to be on the merits of the case. Okay, that's the first part. Second question is, how do you repatriate the money from India? See, this is a very good question. And that's where I stopped when I first talked about the litigation procedure. See, this is a new phenomenon, right? The ordinance in India came only by end of December, I think December 2019 or November 2019. And after that, soon we entered the COVID era. So hardly any cases have happened in this field for us to have experience how we will bring the money back. This is where the assignment in favor of the litigation funder could help. He can collect the money and he has to handle the money there, bring it here and split. The law firm which has a branch in India and here, they can also help you. They can collect the money and pay it there. But of course, in compliance with RBI guidelines and fully observing the FEMA rules, no mini, okay? It has to be very straightforward. And maybe a permission will be required from Reserve Bank of India. We'll have to put in an application for this purpose and get a permission once for all. So we clear this hurdle. Very good question. Thank you for that.
Thank you so much. And the next question is asked by Mukund. In case of the new law related to India, once the judgment is given in by UAE law, can counterparty go for the appeal in India?
No way. That's why I said it's treated as a final judgment issued by a court in India. There is no further appeal. The application is submitted directly to the execution court. You're not going to the regular trial courts after that. The only way they can file a fresh lawsuit and challenge this judgment, asking for nullity of the judgment, just to create problems in execution. But the courts which should not entertain it. Ideally, the court in India should not entertain it because the ordinance, the wording is very clear. It has to be treated as a final judgment issued in India. How can you challenge a final judgment after calling it final? And what is the point in having an ordinance like this afterwards? But still, the nature of litigation in India. I would be surprised if someone doesn't try that. Okay, and it can be, you can get it dismissed easily. It's not difficult even if someone tries those. Ideally, he should not be able to file any appeal. There is nothing called appeal anyway. It is only a frivolous lawsuit what is possible. And a frivolous lawsuit is frivolous and it can be dismissed easily.
Thank you. Next question is from Sridhar. Do we have a successful example of judgment of UAE court being executed in India?
I think I already explained that. It's a new phenomenon. We don't have one.
But what is interesting, Ajay, is that we now have a couple of banks whom we are working with, and who have typically written off the loans in the books because 100% provision has been made, and they don't mind a litigation funder coming in and making an attempt at the cost of the litigation funder to recover the amount. Because in whatever recovery they will be able to make, it will be an income for them. So the banks are now getting very keen. In fact, I will not take names here, but last week there was an article in one of the newspapers that one of the banks has succeeded in winning a case in India against one of the persons who's not in the country at the moment, and it was a substantial amount. I'm sure you all would have read it, so I will not take names here. But yes, I think that is the first case which has seen success. And that will go a long way in setting up precedents for other banks to take action for that. So yes, there is one case which I read in the papers last week.
We have already signed with 2 banks for their cases for assess, search, and execution procedure. And the amount involved from the banks, the judged amounts which have to be recovered from India, $7 billion. It's a lot.
That's interesting. Thank you so much. The next question is from Mr. Mohammed. He's asking, like, he is having a judgment on absconding person in UAE, and he managed to locate in India, and he's willing to settle, but is afraid that he may abscond. So what is the best approach to recover without he being escaping something?
Already absconded or about to abscond?
He's saying that he might abscond.
Okay. Very good. Got it. So immediately go to the execution court, get a travel ban.
Okay.
It's a matter of 1 day. You can get it.
Especially if there's a check bounce, an acknowledged debt, a risk of him absconding. There are urgent courts who will look at it, Shine said 1 day. They'll look at it very seriously and immediately put a travel ban.
One of the today's audience, Jairam is asking from IBPG that his size of the business is very small because he is doing a rental business, but the number of the tenant may be more. So in that case, how to handle this issue, especially check written for insufficient funds? So what are the various ways available for him?
See, when the total amount involved, though it may be number of cases, it can be looked into. A funder will be interested if the number of cases are there and the total value is meeting his parameters. Then, especially when there is a check, recovery or collecting the money through the court procedure is very easy because you get a travel ban, you get an attachment order, everything in 1 day. So you can go to the emergent court and ask for a judgment in an urgent court and in a very fast track manner. So that is what you should not be looking into the regular court to go for 9 months for the first court, then 6 months for appeal, another 6 months for Supreme Court, and then come to the execution. So this is, you have to take that fast track route, and there is possibility. It can be discussed. I'm sure the funders will be happy if there are direct acknowledgement of debt and checks in place.
Thank you so much. Our member Sumit Jain is asking, like, do you have offices in Saudi in order to use your services? I know you have answered that you are basically based in UAE at the moment.
Inshallah, very soon. We have just started. Pray for us, give us more cases. We will go to Saudi as well. No, we have associate offices there. We can take care of it.
Okay, for the interest of the members also, I would like to ask, like, in what areas you have an experience, like in what line of business, or you cover the like entire type of the business, or is there any specific areas which you are focusing at the moment?
Any area, provided the documentation is good, the claim is genuine, the chances of recovery is the other party will not run away before we file the case, then if we will take it. Any area, doesn't matter. Debt is a debt, it can be recovered through due process of law. Not like that.
Thank you so much. Thank you so much. And may I now request Rajiv to start with the next session, which is...
1 second. Dilip sir, would you like to add something on the questions which I took the opportunity to answer it, because it was mostly UAE-centric questions. Would you like to add something?
I think you did a great job answering the questions. In terms of Saudi Arabia, certainly Phoenix, along with Litwins, can address cross-border collection opportunities and asset recovery opportunities out of Saudi Arabia.
Good. Thanks, and very, very good questions. And I'm sure we are available, Shine and I both, at any point of time to answer more questions. And I'm sure most members have our contact details, otherwise the chapter and the IBPG can share. So let's move on to the second topic for today, which is also very interesting and something which has been long awaited, which is basically FDI. So now UAE law, and I'm going to share my screen. Okay, so we want to take up the FDI law now, which is the foreign direct investment law in UAE. And the problem statement that we were looking at here is, are companies looking at getting the investment or management control over the company? So now it is possible. We discussed at the beginning that I think Paddy also mentioned that 5149 rule is there. So it's been substantially relaxed now, and there's a great opportunity for expat-owned companies to own 100% of their company now. How exactly does it work? What the law says, we're going to cover in this segment. What is the objective? The objective is, of course, the government, just like India, where India is now pushing very hard for FDI. India is pushing very hard for now what we call as self-reliance, Atmanirbhar, as the Prime Minister likes to call it. Very interestingly, because I follow a lot of global economy, from globalization, very interestingly, the entire world is now moving to localization. And whether it is US, which is pushing to make in US, or China, which has always done it, or India, which is pushing very hard. And now UAE is doing the same thing, where they want companies to come here and manufacture in UAE or provide services outside from the UAE. So one of the key objectives the UAE government has is to attract large-scale investment by foreign investors. So not only it covers the new FDI, but suppose there are existing companies in the UAE who have invested substantial amounts in the UAE, who have brought in good high technology to the UAE, who has made a difference to the UAE. They are also being given an opportunity to own their company 100%. It is not under an automatic route, but another approval route. So every company needs to go through an approval process. It is not like in India, we have certain FDI which is under the automatic route, and certain which needs approval of the RBI or the FEMA. Similarly, it is here, the DED has been entrusted that role to give approvals to companies for owning the 100% of the companies that is there. So there is a positive list, there is a negative list for that. What I'm going to do now is I'm going to hand over to the expert on the matter, Shayan, who is looking after this part of the law. And Shayan, if you can take over and explain how exactly FDI law works.
Thank you so much, Rajiv sir. Thank you, ICAI and IBPG for giving us this opportunity to give an informative session on the FDI law and giving out this forum to be a part of the most respected members in the UAE of the Indian community. So as Rajiv sir explained, the objective of the FDI law is very clear. Foreign expats should be allowed to own more than 51% in a lot of activities. And this is what exactly the positive list has done. Uh, the FDI law was introduced in 2018, and since then we had not seen a lot much development or an initiative from the government side towards the FDI movement. But luckily, around end of March, this positive list was announced. The positive list basically comprises of 122 activities in which FDI is permitted. 100% ownership is permitted by for a foreign expatriate. There are 19 activities in the agricultural sector, 52 activities in the service sector, 51 activities in the industrial sector. The other key things that one needs to understand about this positive list is that there are certain conditions, necessary conditions, which a company engaging in any of these activities have to follow. Primarily for the agriculture and the service sector and the industrial sector is that they have to submit a business plan which shows that they are following a minimum capital requirement. Each activity has their own minimum capital requirements. They also have to show that they are adding certain high value into the economy of UAE through their activities. Apart from this, there is also a requirement, depending on the activity, that how are you bringing in some sort of new technology which gives you an edge over the existing mode of doing those activities. It may be simply a new machinery, or it may be a part added to that machinery, or engaging softwares or artificial intelligence, whichever way you are scaling up the entire technology game is what they want to actually see. There is one common principle or a condition which has to be followed across all the three sectors, which is the emiratization policy, or what the government calls it as Tauteen Club. What the Tauteen Club is all about is that Ministry of Human Resource is going to set out the number of national employees that these companies, these FDI companies need to engage. So of course, FDI with the coming in of FDI and companies becoming FDI companies, there is no longer the requirement to have a sponsor or a local agent. However, with this emiratization in place, nationals can be a part of this company. That is what the government's initiative is. If we can move on to the next slide, sir. So like I was saying, the agricultural sector has all the four requirements. You have to show that you are following the minimum capital requirement, which ranges from 7.2 million to 10 million. The other requirements are obviously use of new technology. How are you adding new value or adding value to the economy? Are you doing some research and development? And of course, the Tauteens Club or the emiratization policies. Here, one thing I would like to point out specifically is that by minimum capital, it does not mean that the bank account of the company should have 7.2 million in cash. It's basically the total net worth of the company. It's their assets, their loans and facilities that they already have, their foreign investments, which are coming into the company. All these put together, cash in hand, put together is the capital, broad definition of the capital under the FDI law. Now we will move on to the industrial sector. As you can see, the industrial sector ranges from the minimum capital requirement ranges from 2 million to 100 million. Starting 2 million is basically for small manufacturing, which is like manufacturing musical equipments. Then we move on to gaming and sporting events or equipments, which comes to around 3 million of minimum capital. 15 million capital requirement is for the most amount of industrial activities, which includes manufacturing of plastic, rubber, metal related items, food production of foodstuff, locomotive repair. These fall under this 15 million cap. Then comes on to 20 million. Here, some of the other metals fall under this cap. So if you're producing, say, steel pipelines, your minimum capital requirement would be 20 million. Then we move on to the 100 million, which is the massive capital requirement for companies that are engaged in repairing or building of ships or railway locomotives. These are the minimum capital requirements. And like I said before, the other requirements also have to be followed, which is new technology, adding of high value, contribution to R&D, and of course, the emeritization policy. Service sector, however, is free from the first 3 or 4 conditions which have been set forth by the positive list, which is not all the service sectors require to follow the research and development, neither do they have to show how they are adding value to the economy of UAE, or are they performing any research or development. Most of the service activities minimum capital requirements is as per the law, which is not defined under the current company's law. These services include legal consultancy firm, accounting firms, veterinary clinics, advertising, management consultancy, education, and even hotel establishments. Then we go on to the other category which requires a little more capital is healthcare sector and hospitals, which require around 70 million. And most capital requirement falls under the retail trading shops, which is basically malls and the supermarkets and the hypermarkets that we see, that require a capital requirement of around 100 million. And here, the only condition that needs to be followed is registering with the Ministry of Human Resource under the emeritization policy to be a part to obtain the FDI license. Apart from the positive list, the FDI law, of course, comes out with the negative list, which includes 14 activities, which are broadly categorized, as you can see on the screen. The negative list is where an expatriate cannot hold more than 49% shares in that company. Which includes oil and gas, security and military, banking and finance activities, insurance, commercial agency, road and air transport, post and telecommunication activities. These activities, the FDI law has not diluted the minimum mandatory requirements of national shareholding as of today. Then we will give you the brief introduction to how the process of converting existing companies into the FDI companies will take place. Now, we've spent some extensive time discussing with the authorities in Dubai and Abu Dhabi to understand the procedure. So the procedure as of now is, firstly, of course, the partners or the shareholders of the existing companies will have to pass a resolution to basically state that they are willing to convert into an FDI company. Now, depending on the activity that they are currently performing, they have to see whether they fall under any of the minimum capital requirements specified in the positive list. If they do, they have to present an expansion plan and not just a business plan. They have to submit an expansion plan with other application documents to the DED for their approval. And if your activity somehow requires prior approval or approval of other authorities, suppose it is in the health sector, then you require the approval of the health department. If it's real estate related, then you require RERA's approval. So if these approvals are required, you need to take their prior approval before submitting the application to the DED. Once you have submitted the application to the DED will wait for you to finally join the 13th club. Once you submit the proof that you have become a part of these 13th club, the DED is going to give you the FDI license. After you get the FDI license, you have to show a proof that at least 20% of your minimum capital requirement is there in your bank accounts. This law is this aspect that 20% of the capital is deposited has not been completely clarified by the authorities yet. Even the DED currently is seeking further clarifications from Ministry of Economy. What we understand after discussing with DED is that if your existing bank account has certain minimum capital, and then your net worth is also covering that entire minimum capital requirement, that should suffice itself. However, a confirmation to the same is still awaited from the authorities. Once you have this proof that you've met with the minimum capital requirements, then you will register your FDI license with Ministry of Economy and Chamber of Commerce, and then you are good to go to perform your commercial operations. Moving on to setting up new companies as an FDI company, as described, the procedure is fairly the same. Here you have to first select the activity that you want to do, the legal form of entity that you want to choose, whether it's a limited liability company, whether it's a sole proprietorship, if it's a private joint stock company. Some people also have this confusion whether an existing establishment or a civil company can convert into an FDI company. The answer is yes, they can do that. And the direct conversion, once you get the FDI license, you will be considered as the FDI company. So coming back to the new companies, you select the activity, you select the minimum capital requirement, and you reserve the trade name with the DED. Then you move on to seeking initial approvals from the other authorities like the health department or the land department. With these initial approvals in place, you go to the DED, pay your registration fees with the required documents, and you obtain an initial approval from the DEDs. Once you have the initial approval from DED, the other authorities will also grant you their final approvals. And after that, you have to basically show the proof that you are part of the 13th Club, which is you're going to follow the emeritization policy. With that in place, you again go back to DED, and then DED will finally issue the FDI license. Once the license is issued, now since it's a new company, they will have to open a bank account. They have to show that there is at least 20% of that minimum capital in their bank accounts or in the net worth capital. Once that proof is in place, you move on to registering your FDI license with the Ministry of Economy and Chamber of Commerce. And after you've done that, within 5 working days, you're good to go to commercially operate yourself. So now that we have explained the process of converting existing companies into an FDI company, as well as establishing new FDI companies, we would like to highlight and silver line the benefits of the FDI companies. First and foremost, of course, 100% ownership for expatriates, which is what most of the expatriates want, being a part of this country for a long time and adding value to their economy. Second of all is that they have the right to own lands. FDI company can own lands, and there is an assurance given by the government that the land or the FDI project which is being basically undertaken, such as a factory or any other manufacturing unit, if the law changes, the government is not going to take away these benefits. They are not going to take away the land from the FDI company and the shareholders, or they are not going to take away these manufacturing units without fair compensation. They will give you fair compensation, and that compensation will be decided by the court on a summary basis. So the proceedings will be fast, and you will get some amount of money as compensation, which will be fair and reasonable for the amount of money that you've already invested in those assets. The rest of the benefits are evident. You can repatriate 100% of your profits, and you can ask for, you merge with other companies, get more foreign investments. The field is open for any wish that the shareholder has. Moving on from the benefits, these are some of the general frequently asked questions that I have come across, or Goodwins or Litwins have come across from the queries that we from various clients. That is, what happens if the FDI license application is rejected by the DED? Well, the first thing is that the party can re-appeal to the DED. They can maybe tweak the application a bit and then re-appeal to the DED. DED has 15 days to actually decide whether they are going to grant this license or not. If it passes 15 days, then it is automatically deemed to be rejected. And then the only option that the person has is to apply to the court, and then the court again in a swift proceedings, they are going to decide whether or not the application should be accepted. The other question that we've come across is, what is high added value? The authorities have basically given us the answer is that it's not that you are it's how your contribution to the economy through your activities is going to add value to the GDP of the country. That is the basic explanation they have given. They do not have a specific criteria or list of requirements that needs to be fulfilled. It's just a reasonable assumption that a company can provide, or the shareholders can provide, that this is how we are going to add value to the economy of UAE, is what they expect. This has to be this has to be an essential part of the business plan that you submit for a new company, or an expansion plan that you submit before the DED for converting an existing company into an FDI company. The next question that comes to we've come across is, when do you have to deposit the remaining capital? So like the guidelines have basically stated that you have to deposit 20% of the minimum capital in your bank account, or you have to basically prove that you've met with this 20% requirement. DED, or the Ministry of Economy, grants 2 years additional time, since you have the once you get the FDI license, to deposit that entire minimum capital or meet with that entire minimum capital requirements through terms of acquiring new assets, establishing new assets, or such and such. Then we have also faced this question quite often, which I believe would have come across most of the members and attending this event, is what happens to the UAE national partner or UAE national sponsor in the event of conversion? Well, to answer this honestly, we would primarily say that it all depends on the relationship which the expatriate shareholder has with the UAE national partner or sponsor. It could go three ways. Either the expatriate as well as the UAE partner decide to continue with the same shareholding, or at a reduced shareholding for the UAE national, or you come to a separate kind of an arrangement where only the company would be 100% owned by the expatriate. However, there is a side arrangement just as a token of gratitude or goodwill, or a goodwill gesture, where you keep paying some amount of money to the UAE national for being a part of your organization for so long and lending his name in your activities. So these are a couple of scenarios. But however, if the relationship is not that good, then a little bit of internal strategization would have to be done. The next question that we've come across is, what is new technology? Like I explained before, it's any new piece of technology or an upgrade that you can show in the existing machineries, your computer, your software, if it's blockchain based, if it's artificially run through algorithms, if it's an advanced data analysis, which is helping you do your activity in a much speedier manner. These are the new technology, what they are looking for. Again, this is not a mandatory requirement for service sector. This is a requirement which is applicable on manufacturing sector and agricultural sector. But again, the authorities have assured us that it's not necessary that every kind of activity can show a new technology. So on a case-to-case basis, they are going to take it upon themselves to analyze whether it or not it is necessary to say that this condition is absolutely mandatory for that activity. And if not, they are going to proceed with the FDI application. And the last question that we obviously have come across is the emeritization policy, which is like any other emeritization policy. There would be a specific number of nationals working in the company as their employees, and the other emeritization policy requirements, such as pension funds and all these things, would have to be taken care of. So that's all from my side. If there are any, I will hand over the floor back to Rajiv sir to give his last comments.
Thanks, Shan. Before we take on the audience questions, I'll just cover one slide about Litwin. So these are the services that we are providing currently. So of course, managing receivables is the litigation funding service that we're doing right now. And because linked to that is financial restructuring and bank debt restructuring, We are involved in that as well because a lot of times now existing clients are telling us to look at the debts which are bank debts. We do new debt raising, and Shayan just explained details about the FDI law advisory and VAT advisory. So under one roof, we are providing certain financial and legal services. We would be very happy, of course, this is our team, so you've already seen Shine, myself. This is our legal team. Khalid heads our litigation practice. Shri Kumar is a very senior lawyer in UAE. You heard Shayan today, and the other lawyers are a part of the legal team work in good ways. So would be very happy to take any questions on the FDI law or litigation funding as time permits. Stop sharing so we can then take it up there.
Thank you, Rajiv. We have only one question from our past chairman, Prakash Ji Mehta. He's asking is a minimum capital requirement is required to be maintained at all the times, or it can be easier?
Initially, you just have to show that you have 20% of the minimum capital requirement. Then within 2 years, you have to show that you've met with that minimum capital requirement. After that, the authorities are not going to check because it will be just renewal of licenses. So they are just going to be concerned whether you're actually adhering to the FDI law and the other rules and regulations of DED.
I just request all the members, if there is any question,
I have one question, if I can be allowed, please.
Yes, please, Neeraj.
Then in the negative list, there was air and road transport. What about shipping transport?
That's allowed. That's in the positive list.
And positive. And what criteria does it fall in terms of what we have to meet?
If you're
with
manufacturing shipyards, then you would fall under the manufacturing sector. And in that case, you would have to follow the 4 requirements. Of course, the minimum capital requirement, research and showing some sort of research and development, some sort of new technology, and how you're adding value to the economy. And if it falls under the service sector, then only the 13 club. You are following the emeritization policy.
Okay, right. Thank you.
I just request all the members, if there is any question, they can raise it now, or we just move it to the next part of the session, which will be a vote of thanks.
If there are no questions here, I'll just sum up what Shayan said. The advantage for the foreigners living in this country, they've always been depending on a local sponsor, either in the form of an establishment, which is a sole proprietorship, or you create a limited liability company registering 51% shares of your own company which you set up with your hard-earned money in someone else's name. And then you try to create all these sort of side agreements all the place and always remaining doubtful whether this is enforceable, legally valid, or can be challenged, destroyed. And it has always been a very fertile area for litigation lawyers, disputes after disputes, okay? So this is going to be a permanent solution. We are going to face the reality head on. Until now, everyone knew, even the legislature, okay, all the regulators, everyone knew what's happening on the ground, but it was happening. Now we are going to come to the reality. And the answer which provided was too straightforward. Okay, in a one-to-one advice, I would have said the same probably, but it's always good in a webinar. We should maintain that minimum capital guarantee required throughout the company's life. Otherwise, you could end up into trouble. Okay.
And have they released any statistics in terms of how many companies have been actually opened in the FDI route? 100%.
In Abu Dhabi, what DED told us is 0.
Why do you see that? Like, I mean, we have these announcements, and but you know, in terms of actual situation on the ground, they are not taking a shape of what they expect. What's the reason?
The reason is mainly, it's a new phenomenon, completely new experience for the DED people also. They are also not, I don't know whether I'm being too outspoken, they are not fully equipped to handle the situation. So what we are doing is we are sitting with the legal department of DED and working very closely with them to put the rules, establish the procedure, and get it done. What I have done is the first application I have submitted is Goodwill's, okay? So I can experiment with my own entity, right? And then once I get it right, it will be ready to go. So this should happen within the next couple of weeks.
Okay.
Shane sir,
Oh, sorry. Continue.
Yeah, this is Fazia. I had a question. In terms of the timeline, what are you seeing? How fast can you get these FDI approvals, under these new regulations?
Again, a completely a new development, right? So I'd be just, saying something without any backing that I can do it in 3 weeks, 4 weeks now. But it's not a very simple procedure like many people thought. You can just go to a typing center, they will fill the application form and your company will be converted into an FDI. It is not that simple. You need a business plan. There are a lot of requirements to be met. Unless you present it properly, the chances of getting rejection is very high. And as Shayan mentioned during his presentation, DED itself has got 50 days time to accept or reject your application. So what is reasonable to expect then? Should I expect that they will approve my application in 5 days? Or should I be reasonable and say that it could go up to 50 days? I cannot be nicer than the truth, right? So this is what is it in reality. But once the things are happening, we are working very close with DED. We will make it easy. We will establish the procedure. We will get it done. I don't think it requires more than 2 to 3 weeks once the procedure is well established. Like we did, Paddy knows and Sri knows, how we worked with Abu Dhabi Judicial Department when they came to meet us. Now we are working closely with them on a daily basis. See, Hindi got accepted as a language which is acceptable in Abu Dhabi courts. And a foreign judge is appointed and sitting next to the local judges and Arab judges in important cases. All these were our suggestions. Remember, Paddy, when they came to visit us? Okay. So now things are happening. So they are open to open to ideas, open to support. And when they see that we don't have any different interest other than establishing the system clean and supporting the business community here, they encourage you, they accept you, and they work very close with you. This is our experience. So we will establish it, we will get it done. Eventually, it will be 2 to 3 weeks. This is where I want to bring it.
Very good. Interesting.
Thank you. Thank you so much.
More clarification, Shayan. Just 1 second.
We have more. We have two
Just
more
one.
questions.
Just
Sorry?
1 second, please. Huh? Sorry for interruption. Shayan, when you say that this plan has to be implemented, and does that really mean that one has to get rid of their existing employee to fit that criteria if there is no further requirement of new man? How does that work?
No, there is no such requirement that you have to get rid of your existing employees. However, if your number of strength has increased, if you're hiring more number of employees to suit your activity or to upscale your activity, and that certain threshold has increased, say if you have more than 100 employees, then of course 1 or 2 UAE nationals will have to be hired as well.
Okay, thank you. Yeah.
Thank you. We have another question is saying, member is asking like, does education falls under 122 positive activity? What is the minimum capital requirement for establishing a school actually?
It does fall under the positive list, and luckily it does not have a minimum capital requirement. It says as per the law. So, and the law is silent on that as well.
Okay, we have
so primary schools, higher senior secondary schools, they do fall under the positive list.
Thank you so much. One of our members, Saji, is asking like he wants some more little bit details on the service sector activities.
The list is too elaborate to actually speak in concise at this moment. However, if Mr. Saji can share his email ID, we can provide the details over the email.
Okay.
You can always come to Goodwins. We'll provide a free consultation.
Yeah. Thank you. We have another questions from a member like, if it is a technology-based company formed under FDI, can there be another company with the same technology or same machinery, etc.?
I would say yes, there can be. It is healthy to have competition in the market, so it should be possible. Yes.
One of our member, Yogesh, is asking like, one of the reason is too high minimum capital requirement. Maybe after some time they will reduce. What is your take?
that is quite a possibility. As of now, the FDI committee, which has been established under the FDI law, they have the right to decide these requirements. They can reduce it later. They can also introduce new requirements if required based on the market situations, or they can completely do away with these requirements as well at a later stage. One more thing that they can do is they can remove activities from the negative list and bring it under the positive list. And they can also add on more activities into the positive list as and when the time goes by. So these powers have been given to the FDI committee. They can decide on this, and there is quite a possibility that this minimum capital requirements or the other requirements can be reduced or done away with.
And remember, all these numbers are pre-COVID numbers, okay? So it will change.
Yes.
We have to face the reality now.
Thank you so much. May I now move to the next session, which is the vote of thanks, which will be proposed by Faiz. He's an executive committee member of IBPG. So may I request to Faiz and propose a vote of thanks?
And a chartered accountant.
Sure. Yeah, member of both ICA and IBPG. Thank you. So yeah, my role is to give the vote of thanks. We'll keep it very short. Obviously, we had a very long session. In the first session, we had the litigation funding with the background given by Mr. Dilip, which is quite useful to know the history behind it, and followed by Mr. Shaheen and Rajiv talking about their new venture and explaining the nitty-gritties of litigation funding and how it works in UAE. It was pretty interesting to learn the details of how it works, and I thought that it was very timely as we are going through a very difficult circumstance. A lot of people and a lot of companies are facing challenges and litigations on account of the challenges that they've faced on due to the COVID pandemic. So a very interesting venture, and we wish all the best to Mr. Shaheen and Rajiv on this new venture. In the second session, we had obviously Mr. Shahan Dasgupta, who detailed about the FDI promotion in UAE. We all have read about FDI law over the news and in a brief way, but I think this was very helpful to sort of understand the details of what are the sectors, what are the regulations that are applicable, and how we can benefit from that. I'm sure that this is very insightful, and the members from ICAI and IBPG will definitely benefit from it. So thank you, Mr. Shahan, for giving us that clarity. On behalf of IBPG and ICAI, I want to thank each of our guest speakers, members of the ICAI and IBPG fraternity, who have taken the time to sort of attend the webinar today. We hope it was very informative and useful. And please share your valuable comments, because that will help us sort of improve the programs going forward. That brings us to the end of this webinar. Thank you, good night, and stay safe.
Thank you everyone for attending.
Thank you.
Thank you very much.
Thank you so much.
Thank you so much.
Bye-bye.
Bye.
Thank you. Bye-bye.